Good morning, everybody. Welcome to the Courtroom Files Live. It is Tuesday. Happy Tuesday. We're going to start our morning off with Judge Simpson.
But go down to on counts 2, 3, 4, and 5, which would become the attempt. I'm going to need the pack code on that one. It's likely going to be 75545A with a bracketed A.
Correct.
Mr. Simon, any objection to that?
No, Your Honor. Thank you.
I would order that the people are to file an amended complaint in the case so that everything is clear.
We'll get that out to you.
And as to count 5, your client is standing mute to that, Judge.
Thank you, Your Honor. Yes.
And the court will enter a not guilty plea, maintain his not guilty pleas to counts 2, 3, and 4. Count 1 is dismissed. I will set a pretrial before Judge Fleischer,
April 24th at 10 a.m.
April 24th, 2025, 10 a.m.
Your Honor, can I ask a quick question? Is that here?
Yes, it would have to be. It's here.
Right.
May 6th. I don't know if that was she called out.
That what? Who?
For the May 6th. So, yeah.
That would be greatly preferred. It's a DV. She likes to hurry the DV docket, but this is a client who's already been to court, been admonished on his bond condition. That's what she likes to do, and I'm not criticizing that. I'm just stating it factually.
So May 6th,
May 6th.
10 a.m. before Judge Fleischer.
Thank you.
Bond will continue. Thank you. Let's call the case of the people versus, is it Risha Cheatham?
There you are.
Andrew Childers, on behalf of people, Your Honor.
And when you are in the business sorry.
Mr. Simon, get out of the way.
I'm so sorry, Your Honor.
Miss Young was too nice to say that to you, but I'll say it.
Thank you.
Good morning, Your Honor. For the record, reading 2444626. And on behalf of Mr. Shield, two judges present, standing to my right. And would you state the name for the record?
Grace Cheatham.
Thank you. And she's waiving her right to preliminary examination.
Yes,
Is that correct, young lady?
yes.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed in, or the offense alleged was committed in that you committed it. Do you understand you'll not have that hearing? You'll proceed to circuit court for further resolution. All right. People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Sean. You waive,
As to the waiver on the information waiver from the meeting, as the court did or not guilty plea. Sorry, Judge.
no, it's okay. Defendant having waived formal reading, pleading not guilty, court will enter that not guilty plea to that charge. Pretrial in this matter will be set for
June 10th at 1:30 in Court of County.
June 10th, 2025, 1:30 before Judge Conkey.
Thank you, kind sir.
Thank you. And can I speak with counseling back, please? I'm speaking on a separate matter. Yes, please.
Yes.
All right. Court of standard briefers. All right.
All right, well, he steps away. Let's flip over to Judge McNally's courtroom and say good morning to him.
Other party, but I did do a follow-up at the hospital that day, and she did have a laceration on her head that needed stitches. And both vehicles were disabled.
So what do you want me to do on this one? I can't take impeding because of the accident with the hospital transport, or at least her going to the hospital, the laceration. What would you like me to do?
Your Honor, I'd be okay with it just being regular citations instead of the CMV to save her on fines. I'd be okay with that.
So you wanted to plead the both, just
I actually observed. Well, I'll wait to see what she says, but yeah, I would keep both on this because of what happened.
so you got a 3-point violation and a 2-point violation here. And I'm okay if you want to. It's a commercial vehicle, so I'm not likely to reduce the fines, but if you want to give one of these and dismiss the other, if you feel comfortable doing that, but I wasn't there, I don't know what happened. So
Okay, I'm okay with dismissing the improper passing.
So
Traffic signal was I'm good with keeping that one and dismissing improper passing.
man, if you want to plead a disobey traffic signal, that would be a 3-point violation, and the other case would be that's what he's offering now. Either that, or you can go, and that's a 2-point if you improper pass. If you want to go to a hearing on that, you can. We can have the hearing right now. I can swear you both in. Or if you want to take advantage of that, I'll go ahead and dismiss the improper pass if you choose to plead the disobey traffic signal.
I'll take advantage of that, Your Honor. I just wanted to see if I was able to set up a payment plan because I did lose
Yeah,
my.
we'll take care of that. So, but to the charge of disobey traffic signal, how do you plead, responsible or not responsible?
I didn't really, the disobey signal, yes, I'm responsible for that.
I'll accept that plea 235. And I'm gonna go ahead and dismiss violate, okay? So I'll dismiss violate, and that's the motion of the police officer. Are you good with this? I want to make sure, Officer.
Yes, Your Honor, I'm okay with that.
Okay. How much time do you need to pay this, ma'am?
I just started my new job last
Just tell me
week.
when you can pay it. I don't really need to hear all that. You just tell me when you can start to pay this.
I can start paying it, in May.
All right? Can you pay $100 a week and starting May the 2nd?
Yes, I can do that.
All right, now listen, if you don't have the money at any point, so I'm gonna order that you pay $100 a week beginning May the 2nd. If you don't have the money, all you have to do is call the court, and I will go on Zoom with you on or before any due date at 8:30, and I'll be more than happy to get you an extension, okay?
Okay, and that's the total, just the 235?
Yeah, so just be sure to call, and just don't ignore me, I'll be easy to deal with, okay?
Okay,
Not,
thank
don't
you.
call me, but you can call the staff.
Okay,
They're gonna call the staff and they're gonna set us up on Zoom. Okay?
okay,
Best of luck to you, man.
Thank
Are we
you.
looking at Bryant?
I say close.
I got two interpreters here on the.
Judge, the interpreters are here on a different case.
They're not here on Bryant?
No, they're here on Barnes, Jeffrey Barnes.
Oh, okay, all right. Good enough. Okay, yeah, it was close.
Thank you.
So they're here on Barnes. I don't have any interpreters on Bryant, right?
I don't believe so.
Okay. Ma'am, you're all set to go, okay?
Okay, thank you.
Wish you well. Good luck. Good morning, detective again. Do you have another case here?
Yeah, we have a couple PCCs, Judge, that I'm just zooming in case you need us.
Okay, thank you very much. I appreciate that.
While Judge gets his sip of coffee, a more formal good morning to everybody. Welcome to the Courtroom Files Live. Happy Tuesday to you once again. Slower start out in the court world this morning. There's a couple of courts that are active, but most of them are just still kind of drinking their coffee and booting up. So we'll ride with Judge McNally for just a little while until some more stuff pops off around the United States.
Here's the check. I thought they were waiting for me to walk outside and give me some jewelry. What? Or they finally caught up to me after I left Southgate and they got here so quick.
Morning, Detective Davis. David Evan, Marchina, 258-718-222.
With the voting.
Your name, sir?
Alan Marchand.
You have the right to a lawyer. I'll be happy to provide you with one at public expense. Probably should get one. This is a domestic charge. Would you like a lawyer?
Yes, sir.
All right, you go out in the hall, we'll set you up and you'll come back in front of me either way, okay?
Thank you.
Stone, Sherby. Sardina Paving Stone LTD 25S118104. Who's on that one? Mr. McFadden, your name? Mr. McFadden, you can start your video, state your appearance, please.
Patrick McFadden on behalf of Sarnia Paving Stone.
All right, good morning. So you're authorized under this plea, it's an overweight plea. And he's saying he does this without cost. So he's saying 2830 plus costs that goes by the court. Is that right?
Correct.
All right, you're authorized under this plea on behalf of the company.
I am, Your Honor.
All right, to that charge of overweight violation, responsible or not responsible?
Responsible with authority.
I'll accept that plea. I'll assess costs of $129.30. I'll give them till May the 15th, okay?
Yeah, Judge, is there any chance you can extend that and give them a little more time? I know it's a long time, but it's a lot of money and it was one of those frost law ones. They weren't prepared for it.
I'll tell you what, 1,500 due by May 15th. Balance due by June 15th. So 1,500 by May 15th, balance due by June 15th. You're all set, okay?
Thank you, Your Honor. Have a great day.
You too, thank you. People against Lance, Gabriel Richard Lance, 258-231-430 is your client. Mr. Means.
Coming up.
How you doing?
Oh, real good, Judge. How are you?
Good, your appearance?
Bill Columbus, P38434 on behalf of the defendant.
Sir, your name?
Gabriel Richard Lance.
All right, so for purposes of arraignment, he stands mute, waives formal reading.
Yes, Your Honor.
And now he's going to plead the failure to exhibit a hunting license under 324-435-602 with the understanding that the misdemeanor will be dismissed, right?
Right, and what he's pleading to is a civil offense.
Right.
Yes,
You understand that, sir?
I do.
To the charge of failure to exhibit a hunting license, responsible or not responsible?
Responsible.
All right, I'll accept the plea. 175, original charge. I'll take care of that. You're all set.
Thank you, sir.
Have a good day, Mr. Close.
We waive all apologies. Thank you.
Apologies.
We'll see you later. See you.
All right. What else? I don't know what everybody's here. When, all right,
Well, one of my files is missing a ticket. It's just, it has the client's name, but there's no ticket on it.
what's the name of the case?
Those are trucking.
Wait, so we have a case, those are trucking, he's saying that it's,
We have the file, but there's.
no ticket in there.
He can just come down here and we can print it.
Yeah. I mean, just, I'll tell you what, John will go down and get it. John will go down and get it, so you can prepare it.
I have 3 tickets done. I'll just send them.
Good, thanks.
Thanks, Judge. Start then.
Carmen, reviewing reports with, does he have the case on with the interpreters, Lisa, too?
Yes.
Yes, he does.
Is the defendant on that case in here?
Yes.
I left mine on. Good water.
Big year.
Yeah, 8 very much.
So. My, is he working on another case, Lisa, Mr. Carmen?
I have no idea, Judge.
I believe he said he was waiting for the prosecutor.
Waiting for the prosecutor. Okay. Suspense. Who's transporting 25 S118069? This is Mr. What? I believe. Mr. Levitt, you out there?
Okay, everybody, I know that this morning's coming in a little bit like a lamb and a little less like a lion. It's a little calm out there at the moment. I'm flipping through the, what's my list now, 32 different courts that I regularly move in and out of, looking for somebody that's really got something going. But like I said, in the meantime, we'll just ride with Judge McNally while I find us something a little more exciting. We're getting to the point where Judge Fleischer should come online soon, too. Oh, by the way, something popped into my head earlier. For those of you who are closer to my age, since it's a slow morning, I'll ask this question anyways. I don't know why this popped into my head, but it did. So when I was a child, black and white TV was still kind of a thing. And I always thought that when I was watching older shows, especially that were in black and white, that they didn't invent color until the 60s and that the entire world was black and white. Did any of you ever think that? I always did. As I watched old shows and old movies and stuff, I was convinced that the world itself was in black and white until the 60s. Just curious.
William James Barrett III. 259-505-607.
Okay, his hand on his face kind of sums up his courtroom at the moment. So I found us somewhere where there's some action. Let's go to Fulton County, Georgia. This is them working through their all-purpose calendar. This is Judge Morrow.
Position 23, for count 1, that will be 12 months, 96 days to serve, credit for time served, 48 days. That's from February 27, 2025 till today's date. Balance probated, either Operation 21 Law and Decision-Making course or 40 hours of community service. No further contact with Susan Neely. Stay away from 224 Hendricks Avenue Southwest, Atlanta, Georgia. For count 2, that is 12 months, 96 days to serve, credit for time served 48 days. From February 27, 2025 till today's date, to run concurrent with count 1, balance probated and ADET. We ask that the defense stipulate to venue, factual basis, and identification for the purposes of this pleas. And if we can please sound for the victim, Ms. Susan Neely, in case she's present and wishes to be heard. That's all for the state.
If Ms. Neely is on the line and wishes to address the court, now is your opportunity.
Good morning, Judge. Can you hear me?
Yes, ma'am, Ms. Neely. If you would like to address the court, I'll need for you to raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court to be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down, Ms. Neely. What would you like to tell the court?
First of all, Your Honor, I want to let my son know this is so hard for me, but I love my son dearly, unconditionally. We've had a great relationship. He's a good person all around. He's intelligent, he's articulate, but his decision to drink unconditionally and all the time, night and day, has caused him to make decisions that are just, he's not making good decisions. He's constantly drinking. He'll go somewhere and drink, and he'll come here to my house and we'll get into it. He'll destroy my property. He'll come all hours of the night. Doesn't matter if I have to go to work or not, but I just want him to get some help with that drinking. He's a good person. He just don't know how to stop drinking. And he doesn't have anywhere to live. I had to put him out of my house 3 years ago. And since then, he's been on the street, going from home to home, house to house, getting put out because of this drinking problem. I don't know where it's coming from, because we have had a great relationship like 4 or 5 years ago, but lately it's gotten so bad that I don't want to deal with it anymore. And I'm just this action that I'm taking is for his own good. He's gonna get hurt. Somebody's gonna take his drinking and his attitude the wrong way because he gets arrogant, he gets obnoxious, and I can't handle it anymore. And I know other people are telling me when he go to their house. So I'm just afraid that he's gonna end up in a worse situation than he is right now. And I'm asking the court, Your Honor, to please help him get some help with that drinking before he comes back to before he's released from prison.
Okay, so I appreciate you being here this morning, Ms. Neely. Part of the sentence is going to be alcohol, drug evaluation, and any treatment that's necessary. So he's going to be ordered to get treatment if he needs it. Okay.
Yes, sir. And he's also homeless. He needs somewhere to live.
Okay, we'll see if we can assist him with that as well. Okay.
Thank you, Your Honor.
You're welcome. Thank you for being here, Ms. Neely.
You're welcome. Thank you.
Mr. White.
Your Honor, we just asked to accept this plea negotiated, stipulate for the purpose of the plea. We just have as far as the on position 23, he would like to take the law and decision making course, the Operation 21 law and decision making course. And the only other request we have is that on position 20, the stay away from MARTA. He had a MARTA suspension back at the time, or got one when he was arrested. This is a case is over 1.5 years old at this point. We just ask instead of stay away from MARTA, that it stay away from MARTA if there are any suspensions in place.
Okay, so it'll be abide by any active MARTA suspensions for position 20. And we'll make note that he wants to take the law and decision-making course for position 23.
Perfect.
All right. Okay, if nothing further, Mr. Reese, it's my understanding that in case 23 CR 005269J, you wish to plead guilty to criminal trespass. In case 24 CR 000628J, you wish to plead guilty to criminal trespass. In case 24 CR 007310J, you wish to plead guilty to criminal trespass and theft by shoplifting. And in case 25 CR 001633J, you wish to plead guilty to violation of a TPO and public drunk. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I will accept the plea as negotiated, Mr. Reese. I'm going to have you be on probation the entire time so that we can monitor you, but to help you get on your feet, I'm going to waive the first 3 months of the probation fees to help you get situated, get a place to live, get a job. So I'll waive the first 3 months of the probation fees. I want him to have a social worker visit to assist him with housing, Mr. White, so that we can possibly get him located. And
She's here, Judge, and just not at a friendly way. She'll speak with him as soon as we're done.
okay, very good. Mr. Reese, good luck to you, sir.
Thank you. Thank you, Your Honor.
Well, good. Hopefully Mr. Reese is able to get stuff turned around. Judge Boyd is up and running. Let's go say good morning to her.
All right, so we're here for discovery and an offer being due.
Yes, the offer has not been made. Mr. Braswell has been conferring with Mr. Garahan. And I think this is the sort of case in which Garahan would prefer to make whatever offer person
Okay,
rather than defer it to my judgment.
all right. So let me give you a date to come back.
And I bring it to the court now because I'm skeptical that Garahan will be down here in time.
Okay. All right, so what we're gonna do is we're gonna recall you, Ms. Ferguson, on Eduardo Medina, recall him for May 6th. And at that time, the state will tender an offer to you. And then your next setting, I'm gonna give you a plea deadline date.
Okay.
And then if things are not worked out at that time, then your next setting will be a jury trial date.
Sure.
All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Thank you.
And counsel, do you know if you have all discovery?
Yes, Judge, I do.
All right. Well, then,
Shall I generate a discovery?
yes.
acknowledgement, Judge?
So once you sign the acknowledgement of discovery, you're excused. And once you sign the reset form, you're excused.
Thank you very much.
All right, thank you.
Judge, maybe please.
Yes.
You have the seats, or just take it to. Thank you.
All right, we're going to switch back over to Judge McNally. Real quick, a preemptive apology. This week is probably going to be a little bit spotty as far as content beyond the live stream. Yesterday, we had to take Mrs. the Courtroom Files to a doctor's appointment. That was fine. But on the way out the door, we noticed one of our pet rabbits had a eye infection, and by the time we got home, it was super bad. So we spent the rest of yesterday dealing with a vet on that. Got stuff going on today, got stuff going on tomorrow, stuff Thursday. So I'm not probably going to get as much content posted as I normally do. So apologies again for that. We're just going to kind of move through the week as best we can. But I said we were going to go to Judge McNally. Yeah, actually, Yeah, let's go to Judge McNally for just a few minutes.
On the report and the findings in the report that were marked Peoples 1. So now we're talking about waiver of the exam. You are charged with fleeing a lewd third. You are charged with assault, resisting, obstructing officer. Those are 5 and 2-year felonies respectively. You have an impaired driving and reckless driving charge, which are 93-day misdemeanors. You do not have the right to an exam on the misdemeanors. You do have the right to an exam on count 2, assault, resisting, obstructing officer, and count 1, fleeing and eluding in the 3rd degree. Your lawyer tells me you wish to waive that right to an exam. You waive your right to an exam. If you waive your right to an exam, that means as to those 2 counts, you're waiving the requirement that the people show that the crimes were committed and that you were the one who probably committed those crimes. And you will automatically be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Okay.
Do you understand that?
I don't feel like I've resisted arrest, but all right.
Your Honor. You shouldn't talk about the case in open court, okay? You shouldn't say anything except to your lawyer. I just want to make sure you want to waive your right to an exam. Is that what you want to do?
Yes.
Anybody force you to do that?
No.
And you understand now you're going to be bound over for further proceedings to the to the Criminal Justice Center. Do you understand that?
Okay.
Oh, you understand that? Okay.
Yes.
All right. I'm gonna accept the waiver. I find the waiver's been made voluntarily and understanding that you're bound over for further proceedings to the circuit court. If you can remember, Mr. Mohammed, to write no objection to bond continuation.
So the judge, I didn't because I was wondering what his bond.
20,000 PR. You can always see them up in the right-hand corner here of the register of actions.
Understood. And judge, is the defendant on a GPS tether? So Judge, I'm gonna request that the court impose a GPS tether on this defendant. I believe he poses a potential flight risk based simply on the nature of the charge of fleeing. He also poses a danger to the public. He was operating while intoxicated. I believe an additional count is a reckless driving. So based on the nature of the case, Your Honor, I believe that a GPS tether could be imposed on the defendant.
Mr. Strong?
Judge, we've had 6 court dates in this matter, and Mr. Thomas appeared at all court dates. He's not a flight risk.
I don't need to hear anymore. I agree with you. He's appeared in all proceedings. And by the way, if I do that, I'll be sitting in the county for 6 or 7 days. That's not fair. You're bound over for further proceedings to the circuit court. The bond conditions without the GPS tether will remain. You're to continue to test weekly. No alcohol, marijuana, or drugs, AA twice a week, no contact with the victims, no contact with prosecution witnesses. You understand all that?
Yes.
Okay.
Thank you, Judge.
Good enough. That's what we'll do. Thank you very much. Good luck. April
Judge,
29th.
I'm sorry, what date was that again?
April the 29th, 2 weeks
All right,
from
got
today, 9 o'clock a.m.
429. Got it. All right, thank you, Judge. You can.
All right, Judge Fleischer has started his day. Let's go say good morning to him.
So regardless of what she wants, unless the judge gives permission, he couldn't. But from my understanding.
The state can confirm that, Your Honor.
You can confirm?
Wants contacts.
Okay, so I am going to order you at this point not to have any threatening or harassing contact with her. You need to understand that what is threatening or harassing doesn't matter what you think. I don't care what you think. It's what she perceives. So if you go like this to her, that is most certainly threatening, harassing, and it can land you right back in jail. There's a lot of vindictive people in this life, and I don't know what kind of relationship you have with her. But if it's something that you're constantly butting heads, I would be very careful because she calls and makes the slightest, you're the one that's going to end up back in there. Do you understand? All right. So what we'll have you do?
That's a different picture. Different.
Oh, this is not that. Okay. So I'll modify the bond condition. What I'm going to do is I'm going to take off the residential restriction. However, everything in this order still applies and it's stuff that you shouldn't do anyways. So make sure you read it and know what it is. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells you that she can't get a hold of you because you're playing games you pick up a new case or you become a danger to my community, it's not going to go well for you. Do you understand? Good. I hope so. All right. So we'll have you sign a reset. Don't leave until you sign our bond conditions, and after that, you'll be free to go. Thank you. Yes, ma'am.
Thank you, sir.
So can you file no threatening or harassing, please?
Yes, Your Honor. No weapons.
And no weapons, right?
It looks like Attorney Wolford is not in this one, so I printed out a copy of the law that the defendant signed with the project plan. It's very small.
Yeah, okay. I mean, as long as he signed, I'm good. Yeah, okay.
You will need to come in,
Sorry, I didn't know this.
you'll need to come in and sign for a new law on the previous case, because the one that he signed previously.
Yeah, B. Davis, he's worn that suit a couple of times now. We've got a few videos with him in that suit. Very bright, very Easter week, I would say. But yeah, it's a statement, that's for sure.
For this one, there was a co-defendant, Allen. Can I get the case number for that one?
Yes, Your Honor.
How old are you, Mr. Pullard?
21.
Okay. Are you here with anyone today? What, do you have the cause number for the co-defendant?
Yes, Your Honor. Sorry, so working on it. The cause number, Your Honor, is going to be 255-9110. And 255-9112.
They're disposed.
I'm sorry, Your Honor. Yes, Your Honor, that's correct. Both those cases have been dismissed.
Okay. Mr. Pullard, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 7, 2025, in Harris County, Texas, officers a theft shop looking call and an off-duty officer who had detained the defendant and a co-defendant. The off-duty officer was informed by mall security that the co-defendant had stolen merchandise from Zoomies and passed all points of sale and ran out of the store. The co-defendant then ran to a car in the parking lot where the defendant and another individual were located. So he blocked in the vehicle and were able to detain the defendant and the co-defendant. Officers found a handgun in the glove compartment of the vehicle. They said the handgun belonged to him. And the officers observed a strong odor of marijuana.
The officers what?
Observed the strong odor of marijuana.
Okay.
The defendant did state he had weed or marijuana in his pocket. The officers retrieved a bag of a leafy green substance from the defendant's pocket.
You said he's a passenger though, right? Or was he the driver?
I believe he was the driver. Let me make sure that's correct, Your Honor. He was in the driver's seat.
Mr. Pullard, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run his license, please?
Yes, Your Honor.
What do you do in life these days, sir?
I just finished electrician school out in Port Arthur. I just recently moved back to Houston.
Did you get your license or no?
Only thing I have from the school was like an OSHA 10 certification, but and basic training of electrician, but it's more classes I have to take to
Get on it, doggone it. What are you waiting for? You know?
It's just a lot. I had a lot of family issues going on with like moving back and forth from Houston and Beaumont. Where I was staying at in Beaumont, our house, during the storm, it messed up, but I was only staying out there because of the school. But now our house is getting repaired.
Are you living here in Houston now? Okay. I'm going to appoint your lawyer today, Mr. Pollard. I don't want you to get in any more trouble, and I don't want you to use You're not to be in possession of weapons. I'm going to test you 50 days from today. If I find that you're using, it's not going to go well for you. You understand? I don't want you hanging out with the co-defendant in this case as well. You know, it just, you're on a fast track to nowhere. You have the opportunity to get a really good job. Electricians can make, I mean, a killing if you do it well and you get on it young. Well, you're now, but I'm telling you, this is not a good way to start. Do you understand? So I'm bringing you back in 2 weeks and I want to see what you have done to further your electrician career. Get back into school, get back into so you can get your license. Do you understand?
Your Honor, his driver's license is eligible.
Great. You may drive as long as you have liability insurance as well. You cannot drive unless you have car insurance. You understand? I'm making that a condition of your bond as well. Okay, so to test in 50 days, no alcohol, no illegal drugs, and back in 2 weeks to see what he's done for school or work. Okay. All right. I'm going to appoint your lawyer today. You're going to sign a receipt with Victoria. You'll meet with Anthony for pretrial services, and then we'll have you take your seat in the jury box. Please.
This way. Judge, counsel is approaching for page 20. Santa Bonilla.
Yeah. Are you doing a plea?
No, this is an arraignment, but I also have a plea.
Santimanes
Is an arraignment.
109 days old.
Yes, apparently, we just got hard on this case. Apparently, he supposed to come to his first setting. But he tells me he couldn't get a ride, so he didn't come. So here we are. He posted a new bond. So it's as though we're starting over. So I just need to look at the discovery and then we'll go from there, Judge. It's a .07, not .076. Expired.
Mr. Santimanes, you are charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Judge, on December 27, 2024, a law enforcement officer was dispatched from Clear Street and Allenville Road to back up an officer on a traffic stop. Law enforcement officer had stopped the defendant's motor vehicle for expired registration and loud noise and vibration. The law enforcement officer made contact with the defendant, the driver, and the law enforcement officer observed the defendant spraying cologne over his body several times. He also observed the odor of an alcoholic beverage, red watery eyes, slurred speech, and the defendant stated that he was drinking alcohol at an unspecified time with some friends at a trailer park. The defendant's girlfriend requested they meet, which is why he was crying. The defendant consumed 3 bottles of 12-ounce Modelo beer approximately an hour prior to the law enforcement officer contact. Sanitary spray tests were administered. And the officer observed 4 to 6 on the HGN, 4 to 8 on the walking turn, 4 to 4 on one leg stand. And while administering the HGN, the defendant had a distinct side-to-side sway.
You say side-to-side sway?
Correct, Your Honor.
Okay.
During the walking turn, the defendant used his arms for balance for the entire test and hopped to maintain balance for approximately 2 seconds. The defendant consented to a breath test and to .076 and .073.
Okay, Mr. Santibanes, I'm going to find that there's sufficient probable cause to go forward with your case. Any prior to DBIs, does he have a license?
He does not, Your Honor.
No prior to DWIs and his license.
Okay, as long as you have a valid Texas driver license and liability insurance in your name, you may continue to drive. I am ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, it will not go well for you. I will put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they can put an immigration detainer on you and you will be stuck like Chuck in there until this case is over with and then you get shipped off to immigration. Do you understand?
Yes.
So your case is now 109 days old. We don't set cases very long after for trial, so get ready. Do you understand? Okay.
Yes.
I'll have you sign a receipt with Victoria. After that, we'll have you meet with pretrial and then you're good to go. Thanks, Marcus.
Thank you, Judge. And then for my plea, you want me to wait?
That was the last arraignment. Judge.
No, okay.
Let's do it. And then I think, Jesse, you have one too. We'll get to your.
It's Chirinos, Chirinos. May I call him up?
Chirinos, come up.
Things are starting to pick up in a couple other courtrooms, but if he's doing a couple of pleas here, we'll just take a look at those and then go from there.
Actually, Jesse, let's do both of yours. Why not? Yeah. We might as well kill two birds with one stone.
This is William Hernandez.
Okay.
I need a touch.
Okay. Gentlemen, this way. Both of them?
Yeah.
Okay, both of them.
Okay, one at a time. Hernandez, Quinteros.
The test results from yesterday. This tested yesterday and going for the day. It is 2534. 7. All right, the same.
La señorita aquí, la
Both are true first, right?
Yes, Your Honor.
interesará si tienes las consecuencias.
Both of you are charged with criminal cases. You're charged with driving while intoxicated. Both of you have breaths over 0.15. That makes it now a Class A misdemeanor. You are facing a year in jail and or a $4,000 fine. Both of you have negotiated plea bargain agreements for essentially slaps on the wrist. After today, each of you will be facing 90 days in jail for any other DWIs that you pick up. And I will tell you now, if you're ever in a car, you get pulled over, first thing officers do is they look at your record. If they see that you have prior DWIs and they go up to your window and they smell alcohol or dope, it's probably not going to go well for either of you. So if I were you, I would never get into a car and drive, even if you've had a sip of alcohol, because you're taking a huge risk, especially if you're not in this country with permission. Do each of you understand?
Yes,
sir. Minimum of 90 days in jail from now on. No more slaps on the wrist. Both of you give up a lot of rights by entering into these agreements. You're pleading guilty to these charges. They will go on your record. They will be there forever. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. Both of you give up the right to appeal as well, meaning that once you plead guilty, there's no changing. Do each of you understand?
Yes, señor.
Yes, sir.
Is this what you want to do?
Yes, sir.
Sí, señor.
Yes, sir. Yes, sir.
How do you, each of you plead to the offense of driving while intoxicated?
Sí, es culpable, señor.
Guilty, sir. Guilty, sir.
I want you to understand that everybody makes mistakes. When you continue to make mistakes, when you endanger other people's lives, that's when we really come down hard on you. There is a $4,500 surcharge that would normally apply with these types of cases. I understand that mistakes happen, and I will take it off of you now. But if you make another mistake and you pick up another DWI, a second DWI, it's a surcharge of $6,000. And if you don't pay it, every $100 you owe, you sit one day in jail. not to mention the minimum 90-day sentence that there is. So get a clue. If you want to drink 32 beers, 52 shots of tequila, take an Uber or find another way to get around. Do you understand? I'm going to suspend both of your ability to drive for 90 days. Do not drive. Otherwise, you will be back here. Mr. Chirinos, I'm going to sentence you to 6 days in jail. I will give you credit for the 2 days that you have done. Mr. Hernandez, I'm going to sentence you to 3 days in jail. I will give you credit for the 1 day that you have done. Good luck to you, gentlemen. Thank you, guys. Sure. Hi. Okay, who's your guy?
Fuentes Lobo, and I got the contract now. They sent the contract this morning. Yeah.
So we'll give you 2 to 2.5 weeks.
Okay, appreciate it.
If it's not done by that point, I'm going to bring this person back day for day until they get it done.
I told you.
Good.
Okay.
Let's switch back to Judge Boyd for a little bit.
Appropriately for court. How old are you?
19.
All right.
He
So,
looks young.
yes. Well, I mean, because he is young.
Yes, he is.
So what is happening with this case?
We're gonna work it out, I think, Judge. So if I can get a reset to have him start and hopefully complete a couple of the things that the state's asked him to do, which is.
All right.
Just-
So,
Sorry, just as far as discovery visit's been completed, tendered an offer for resolution to them that would take maybe 30 days to get.
okay.
Yes.
All right. So here's the thing. You're in adult felony court, and I'm telling you this for your own good. This nonsense that young people are doing, it will come back to bite you when you're trying to further your career and do other things. So you need to make sure that you stay on the straight and narrow. And if there are any friends that are out there who are pulling you away from the straight and narrow, they're not your friends, because they should be wanting the best for you instead of having you come into felony court. You understand?
Yes, Your Honor.
Because you see the people in the box, those are people who are brought over from the jail. All right? So do better. Okay? All right. So you want a 30-day reset?
You think, yes, please.
All right. Ms. Ferguson, I need a 30-day reset.
Thank you, Judge.
May we fix this?
Oh, once we get the date.
Sure. Thank you.
All right, May 20th.
Yes.
Are you in school?
No, ma'am.
All right. What are you doing with your life?
I'm going to the Marines.
Okay. All right. Well, I tell you
Been
what.
accepted, Judge, and so if we can get this resolved, he was supposed to ship out and they didn't realize it until they checked again.
Mhm.
And then this warrant came up, and so we have been desperately trying to get this worked out.
All right, let's go.
All right, she just muted herself. She went off the record in private. Let's go to Judge Simpson.
Okay, so the people versus Derek Graham.
Is that on behalf of the people, Your Honor?
All two. Thank you.
Your Honor, today's the date and time set for preliminary examination. At this time, as case 24 FB 1431, the people are unable to proceed as to count one, as that count 2 be remanded to district court. And in case 25 FB 1109, people would ask the court to add count 2 of misdemeanor stalking. The PAC code 750.411H, and we are unable to proceed as to count 1, would ask that count 2 be remanded to district court. Your Honor.
Your Honor, with regard to, and apparently I have the case numbers reversed, but it doesn't really matter at this point. In both matters, Your Honor, I ask that the felony charges, count 1 in both files, be dismissed.
All right, in the case ending in 1431, that'd be the easiest one for me to do. I will indicate count 1 is dismissed, continuous plea to count 2 of not guilty. I'll set a pretrial in that matter at 14B4. Yeah, for in custody.
Friday.
Before I give you a date on that, let me,
We're
Yeah.
gonna ask the court for a bond on that matter, Your Honor. So if we could just take care of the other matter, we can address both cases.
all right. And so dismiss count 1, you're adding misdemeanor stalking
Correct, Your Honor.
in the PAC code on that.
750.411. It's 1 year, $1,000 fine, 5 years probation.
Just 411.
Correct.
All right. 1 year, 5 years probation. Good.
I'm sorry, Your Honor. My client was asking me a question.
No, it's okay. And so you waive any further formal reading of that and are not guilty pleas to that. All right. Count 1 in that case is dismissed. I'll set pre-trial in these matters. All right. In both cases, pre-trial will be set April 28, 2025, 9 a.m. before Judge Washington. And as to bond, Mr.
Your Honor, bond was, and I apologize because I forgot to look and see what the bonds are in these matters, but whatever they were set obviously at a time when Mr. Graham had felony charges pending. Those 2 felony charges have now been dismissed. Mr. Graham understands that if the court does allow him to be released, whether it's on a PR bond or a low cash bond, that if he violates bond in any way, those matters could be reinstated. And I'm sure Mr. Graham does not want that to happen because today is a step forward with those cases dismissed. Your Honor, I'll have to ask Mr. Graham, the address I have for him is a Detroit address because that's who contacted me to represent Mr. Graham. I'm sure the court is going to ask if he's released, where he would be staying. And I would ask if the court would consider a PR bond with a GPS tether, no contact, no go-to. I think it would be appropriate in this situation.
I have, just speaking of addresses, I have a Miami Avenue in Ipsy.
Sorry?
Miami Avenue in Ipsy.
That would be his home address, Your Honor. I just didn't know what the alleged victim was also at that address.
Well,
she's not.
My no go-to is for Dakota Avenue, so I don't. Is that? All right. Okay. All right. So people's response.
Your Honor, we would object any modification about, we were in contact with the victim as recently as Friday, and she was on board the prosecution. We haven't heard from her today, and we have great concerns as to that aspect. But also in this case, we have great concerns given the threats that the defendant was sending to the victim, including threats to shoot her, to kill her, kill one of her kids, saying things, I'm about to kill one of your kids, bitch. As soon as I get my money and buy me a gun, I swear to God. And then the other case, saying things along the same lines of wanting to kill her kids. I swear to God, I'm going to shoot up in that bitch. I'm going to hit one of them bitches in the head. I'm going to catch one of your kids and I'm going to mark your ass. I don't care about going to prison. I can't wait to catch some of your kids. I'm going to kill you in broad ass daylight. So I have great concerns given the nature of these threats and given that we have not had contact with the victim today, but she did recently on Friday and that she was on board. We have great concerns. And I also believe he has a loan out of Jackson County for child support as well, Your Honor.
If that's the case, I was unaware of that part. The part about Jackson, that could be addressed if he's released on bond from here. Your Honor, in regard to the threats, I know this court knows it's not unusual in a case of this type for the people to have contact with the witnesses or victims a day or two before when they don't show. This is certainly not the first time that's happened. But all I can tell you, Judge, is something happened to the victim between last Friday and today. It wasn't my client, because he's been sitting in the Washington County Jail. Yes, he may have made some threats. I can't dispute that because I'm assuming those were taken from jail calls. But yeah, when someone's sitting in jail, particularly at the beginning, they get upset. I understand that, but obviously no one's been killed that we know of.
And Your Honor, these threats were from the police report, not from jail calls. They were
Okay,
from
sorry.
what he sent the victim's phone that led to the charges.
So he was out. He was not in custody when he allegedly made these threats, and nothing happened to anybody. So Mr. Graham doesn't get insulted. What's running his mouth? Right?
When he's out, is he working? Or,
He's been in custody for a while, Your Honor, I assume, so I don't know the answer to that question.
got it.
Charge set up for April 1st, and I said it on this misdemeanor. And they, I had one that prosecutor was Woods, and it was addressed, so it should have been a problem. But I had a job, I was gonna start April 1st. And no, I think they need to go to bond, but she said she wanted to say after this case.
Right now, his bonds are set at $100,000 cash surety in each case. I'll reduce the defendant's bond in each of these cases, $25,000 cash surety in each case. Defendant must be placed on a tether, which is the previous order prior to any release. Now, the only I don't know. Oh, okay, they both do. The tethers, as they read, are exclusion zones around the Dakota address. So, sorry. All right. Thank you.
You just one moment. My client seems to think that the bonds are 50,000.
Did they get changed at some point?
The bonds I had originally were both 100,000 cash surety, but we're not.
He's on 2 felony cases.
And then he has a misdemeanor case of now he's saying that I would give it 14 feet.
So he's
So
reducing
that bond that he's referring to. It's 100K cash surety.
Yeah, that's what I had.
That's for the felonies?
On these two cases, I had 100,000 cash surety on each case. All right. Thank you.
Thank you.
Okie dokie, I'm looking at, 12 different courtrooms at the moment. Judge Fleischer is eating candy, trying to stay awake. Judge Boyd is making notes on stuff while people mill about her courtroom. By the way, that murder trial that she had for 2 weeks, that jury got a verdict yesterday, if you haven't seen that. And that's, I don't want to give it away if you haven't seen it, but there's a verdict there. Several other courtrooms in recess. Yeah. Okay. Real quick, channel members, I wanted to take a second and point this out. I made a decision yesterday. Mrs. the Courtroom Files and I actually made a decision. We are going to do something that's going to massively, massively increase the amount of exclusive content that you're going to get. So it's going to take me a little bit to get that up and running, a week, maybe 2. But stay tuned because you're about to get a massive amount of exclusive content if you're a channel member, and I think that you'll enjoy it. Matter of fact, I know you will. I'd be surprised if you wouldn't. But if you're not already a channel member, please consider becoming one. It's $2.99 a month. You get a lot of exclusive benefits, and that, as I just explained, is about to go through the roof, and the price is not going to increase for it. Plus, it really goes a long way towards helping the channel monetarily, but even beyond that, I like the community that it builds personally, because it allows a separate space from just the channel for those who are really into it to kind of come together and interact, and I really like that. B. Davis, what's that fork friend behind you? That is Forky from Toy Story. Actually, I need to change it up back there. Maybe I'll try to get that done for tomorrow. I've got some Easter Legos and stuff that should probably go out, so I'm gonna look at that. Let's go to, it's a good morning for this. Let's go to Judge Raquel West. We don't often go to her, but she's entertaining to watch, and she is about to start her morning parade of orange. So let's take a look at that.
So, Mr. Carino, in cause number 24 DCCR 2350, And we've gone over this before, but let's go over it again, make sure we're all on the same page. You're charged with a first-degree felony offense of aggravated sexual assault of a child from October 5th of 2024. Your indictment alleges that you were previously convicted of robbery, a second-degree felony, January 11th of 2011. And after that was final, you were convicted of possession of a controlled substance, a third-degree felony, August 2nd of 2023. And what that means, and we've gone over it again, is that if you go to trial and you're found guilty, you would be considered a habitual offender, which means your minimum punishment would be 25 years in prison, up to 99 years or life. Do you understand? And I have a new plea bargain rejection that you've signed with Mr. Matuska that looks like it made a small modification in the offer. And it shows that the state has offered, if you wanted to enter a plea of guilty, a 35-year term in prison or a cap of 40 years. I'm sure Mr. Matuska's gone over with that with you. You have every right to reject that and have your case moved to the trial docket. Just want to make sure you understand the possible consequences and your options. And you understand all of that. Is there any reason to believe, I know this is Mr. Nichols' case, but is there any reason, any notations about why this would change?
No, Judge. In fact, he said he figured it would be a rejection and it would be reset for trial.
So I want to make sure you understand, Mr. Carino, that once your case gets moved to the trial docket, I'm not going to accept this agreement. It either goes to trial or it's some different agreement unless there's some new information or evidence that your attorney or the state attorney gets. Do you understand?
Yes, ma'am.
Okay, we'll get it set on the next available trial docket. Mr. Matuska will begin preparation for trial.
Thank you, Your Honor. Just a note, last hearing we had not obtained the media discovery. We have obtained that now.
Okay,
So we have
so you have everything. Perfect. Okay, then we'll get it moved as quickly as we can. Okay. Okay. Mr. Bradford on Michelle Cormier.
Yes, ma'am.
Good morning.
Mr. Coleman, how are you today?
Right here, ma'am. You are Michelle Lee Cormier, and Ms. Cormier is charged with the first-degree felony offense of murder in cause number 25 DCCR 0153. Mr. Radford has filed, there's a motion to quash the indictment. The state has filed a reply. Obviously, I've looked through both of these. I guess I'm confused, Mr. Radford, when you say it doesn't allege the requisite mens rea for murder?
Judge, if I may, the common law has established that murder is when someone intentionally, knowingly causes the
Okay,
death
but the statute is what we're gonna go by.
Yes, ma'am. But
Okay.
I don't think it was the intention of the legislature to remove the requisite mens rea,
What makes you think that?
because the common law going back 1,000 years has required murder to be intentionally and knowingly.
But they've added
Right.
section B4, which it's a little confusing because the caption states it's 1902C, but the way it reads is the way B4 reads under 1902, which requires only knowingly, not intentional, knowingly manufactures or delivers a controlled substance included in penalty group 1B, blah, 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 that's fentanyl, that's what the allegation is. And so it actually has the mens rea of knowingly deliver. I mean, it reads straight from the statute, so I'm going to deny that motion to quash.
Can I
Sure.
just make a brief argument?
Yeah.
Under this indictment, under the way that it's pled, if a doctor gives a patient fentanyl and that patient dies, then that doctor can be charged with murder even though he did not intentionally or knowingly.
Well, there's an exception. The next C, except as provided, well, where was it? I saw this. It is a defense to the prosecution under section B4, which is our section, that the actor's conduct in manufacturing or delivering was authorized under 481 Health and Safety Code or state or federal law, which I think would be the medical purposes. So there's an
Is it
exception.
my understanding then, is the court of the opinion that the state must prove that my client knowingly delivered fentanyl to an individual?
That's what the law says, and that's what the indictment says.
I-
Did then and there knowingly deliver a controlled substance, namely fentanyl, and that Shelby Irvin died as a result of ingesting and inhaling that into her body. So
So that it's the opinion of the court that Ms. Cormier must have the requisite knowledge that she was giving her fentanyl?
I think that's.
I think
Go ahead.
what Mr. Radford's trying to do is box the court in here.
I'm not gonna.
My interpretation of the statute is just knowingly deliver a controlled substance. And that controlled substance, if it contains fentanyl, is enough for her to be guilty of this offense. If it contains fentanyl and causes the death of a person, then that gets us to murder.
Well, I think that's going to be another whole question because it's specific that
It says knowingly to.
knowingly deliver a controlled substance, namely fentanyl. So I think that's going to come down to maybe a jury question. I don't think that's, I'm not going to make that decision. That's not a,
Right.
I mean, that's just an element of the offense. So
I
the
would-
motion to quash is denied.
Yes, ma'am, I would submit that the statute is unconstitutional as drafted.
Okay. I'm not going to find the statute.
I understand.
I'm going to follow it as written.
Yes, ma'am.
All right, so that's denied. Hold on just a second. Then there's additionally, I don't see an order on that motion to quash.
I can.
I got one.
Okay.
So
So
that's,
oh, thank you.
then in addition, okay, I'm just gonna set that right there for now. There's the order. Okay, Mr. Radford has also filed a motion to reduce the bond, which is currently, hold on a second, let me get to all that stuff. Thank you, ma'am. Oh, it's, you filed an application of writ to seek reduction. Currently set at 500,000, okay. Do you plan on calling your
Yes, ma'am.
client? Ma'am, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, you may proceed.
For the purposes of the hearing, this hearing only, we call Michelle Cormier on the issue of bond reduction. Can you state your name?
Just so you know, once she's under, I mean, there are, I don't let anybody go far, but if she's under oath, and I am allowed to take into consideration some of the underlying facts of the case.
Yes, ma'am.
We won't go far, but just don't want you to think that we're not, can't go there at all.
Yes, ma'am. I
Okay.
understand. Can you state your name for the record?
Michelle Lee Cormier.
And you are the defendant in this case, is this correct?
Yes, sir.
And your bond is currently set at $500,000, is that correct?
Yes, sir.
Can you afford a $500,000 bond?
Yes, sir.
Do you have assets in your name that you could liquidate to make a bond?
My family does.
Your family can help you? Have you talked to your family about possibly helping you with the bond?
Yes, sir.
And how much, what kind of bond do you think your family can come up with?
100,000 or less.
100.
That's what all of them have told me.
100,000, you think they can make a $100,000 bond? Would it assist your case in the presentation of your defense if you were bonded out and could assist me in working on your case?
Yes, sir.
Where were you born?
I was born in Beaumont, Texas.
Okay, have you lived here how long?
I've been back down in this area since I was 13 years old, so.
So you pretty much lived here your whole life?
Yes, sir.
And you have family in this area?
Yes, sir. Jasper area, my aunt here in Beaumont.
Where would you live if you made bond?
The Golden Triangle, Beaumont, or Bader.
Who would you live with?
My aunt, my 83-year-old aunt that comes and sees me, or my son and his grandma in Bader. My aunt lives here in Beaumont, off of Major Drive.
if the court set conditions of your bond, including a GPS monitor and random drug testing, would you agree with that?
Yes, sir, I sure will.
What is your criminal history? Have you been to TDC before?
Yes, sir, I went for a burglary of habitation back in 2013.
How much time did you serve?
I made my first parole, and I served 2.5 on that 10 because they sent me to safety. And I successfully came off of parole July the 11th of 2023.
That's a witness.
I want to know, I'm trying to, I think it's probably in this reply. What was Ms. Cormier in custody for
Or theft, if I'm not mistaken, Judge.
when this happened?
Yes,
Okay.
ma'am.
So the allegations here are that you were in custody for theft.
Can I rephrase that?
No,
Okay.
just
Okay.
answer her
Yes,
question.
ma'am.
In custody, smuggled in some drugs of some type in your vagina that you gave to someone else that the allegation is led to her death that had fentanyl in it. Am I correct?
That's it in a nutshell, Judge.
All right, go ahead, Mr. Coleman.
And you don't disagree with the judge's assessment that you in fact smuggled fentanyl into the jail?
I'm gonna object to that. I think you said the allegations are, what he's trying to do now is bind her into a confession.
I'll move on, Judge.
Thank you.
While you were in jail, did you provide a controlled substance or substances to other fellow inmates?
Again, Judge, I'm going to object that is not relevant at this time.
I'll move on, Judge.
Thank you.
Where did you get those drugs?
I'm gonna object at this time, Your Honor, to that.
I
It's
think
not
any of
relevant.
those are going to go to her Fifth Amendment right
Yes.
against self-incrimination,
Yes, ma'am.
Mr.
One last
Coleman.
question. When you were arrested on the theft offense back in November of 2024, did you have a pending felony drug case in Orange County? Had you been arrested for methamphetamine possession in Orange County?
Yes, ma'am. Yes, sir.
That's all I have.
What's the status of that case? Do we know?
Still pending as far as I know.
Okay.
I don't think it's been filed. But
Okay.
if it's orange, it could
They're
take-
waiting on
It could take
drugs
years.
testing. Okay, anything else?
No, ma'am.
No, ma'am.
All right, based on the criteria under 17.15, the information that I have, the nature of the offense, I'm going to deny the petition or the request for a reduction in bond. I think 500,000 is adequate based on the nature of all of those matters. All right, anything else then on this case?
No, ma'am.
Okay, we'll reset it for an announcement.
Thank you. May I be excused?
Yes, thank you.
Judge, for the announcement purposes, I am waiting on a report from my expert, and I anticipate that will be early June.
Okay, we'll just do a normal reset and we'll see where we are at that point. Thank you. You can go back with the bailiff.
May I be excused?
Yes, sir.
Okay, so real quick while she's between things, actually, let me hold on this. There's somebody actually in front of Judge Fleischer, so let's go there and then I'll come back to what I was going to do.
Care how old you are. I don't care how young you are. You go out there, you start acting a fool. It's not going to go well for you. Do you understand? I just set someone's bond now at nearly $30,000 because they're out there running amok. Don't do it. I'm going to test you 50 days from today. If I find that you continue to use, it's not going to go well for you. Do you understand? We need to do probable cause on the new B&B because we haven't done it. So do you mind? On the new case,
Is that failure to ID?
no. So there is a failure to ID. There's one BMV, and I guess later on in the day goes out and allegedly has another BMV.
Yes, Your Honor.
Okay.
On April 7th, 2025, law enforcement officers were dispatched to a burglary call in Harris County, Texas, and met with the complaining witness, who stated that around 6 a.m. he heard his car alarm going off and observed 2 males wearing all black making entry into his vehicle. Another law enforcement officer that was dispatched to that location observed 2 males matching the description in the same area, and the defendant had complaining witness's key fob on his person that was in the middle console of the vehicle. I believe when they broke it.
So that's how they put him, because he's got someone else's key fob.
Yes, Your Honor.
Okay.
Then he was identified by mobile AFIS.
I think I need to get attached to that third one.
We'll attach you to it now. Yeah. So do you want to file I guess another one because he has a new case?
The one in Fort 16?
Yeah. Or I guess we need to get it over here. You want to do a transfer? Okay. Yeah. You
That's
want
what I was gonna say. On mine, it was still showing.
Yes. I don't want you out in the middle of the night. I'm going to put a monitor on your ankle so I know where you are at all times. I don't want you to have any contact with the complaining witnesses in this case, and I don't want you to go anywhere where they live. You pick up a fourth case, I'm gonna go haywire. Do you understand? What are you doing with yourself these days?
No, I'm gonna finish school and I'll think about joining bed there.
Not why you have all these cases open. Did you not get enough sleep last night? What-
Not really.
While these cases are open, you must either have a job or get back into school full time. When you have too much time on your hands, you become self-destructive. And the days of you just sitting doing nothing are not going to happen. I'm bringing you back in 2 weeks and I want to see what you have done to get a job. If you have done nothing, it's not going to go well for you. Do you understand? Do you have an ID? Okay, I want you to start going and applying for as many jobs as you can, or you get back into school. While these cases are open, military is not going to take you. I don't think if that's something that you want to go do, that would be great because that would give you great structure, which you probably really need. I mean, the military would be a fantastic idea for you that would really, could potentially put you on a career path that could just lead you to the clouds, really. What you're doing now, you're charged with 2 counts of burglary. You know what that'll do to your career? Who hires burglars? No. You think you won't even get financial aid with that kind of stuff? Really, it will hose your whole career. So for now, you must either get a full-time job, start looking into going back into school, but you doing nothing, it's not going to happen. Do you understand? All right. So what we'll do is we'll bring him back in 2 weeks. We'll see what he's done. I'm going to test you 50 days. Don't use. And I'm giving you a curfew of 9 p.m. to 6 a.m. Do you understand?
Yes, sir.
If I find that you're out past curfew, I will revoke all of your bonds. They're going to go high. Okay. Thanks. All right. Take care, Mr. Bullock.
Okie dokie, back to what I was going to get into. On your screen right now is that poll that I put up 4 days ago. We talked about this on the live Friday, maybe. And this was a poll that I put up in response to the video where Judge Fleischer was taking a plea and then he heard the victim impact and it was a very emotional victim impact. And then all of a sudden on a dime, he's like, I'm not going to take this plea. So I asked the question, should emotion affect his or her rulings or sentencing? We've had 808 votes now. 57% say no, 5% say yes, emotion matters. 38% say maybe. So the reason why I wanted to put this up is, number one, I was curious what the community thought on it. But beyond that, going into this, I was probably a no vote. Only the law matters. But I've allowed myself to think things through. And I'm now of the opinion that the correct vote, at least in my mind, is maybe. Depends on the situation, which is currently at 38% of voters. Here's why I think this. So earlier, and this is probably why it popped into my head because I was already thinking along these lines, we were talking about old black and white shows and TV and how when I was a little kid, I thought that the world was black and white and they only invented color in like the 60s. Not just shows, but like the whole world was just black and white. But I've also always said that the world, ironically, I grew up thinking that, but the world is not black and white. It actually exists in the grays in the middle. And if you look at color, white and black are not colors. White is the reflection of all colors. Black is the absorption of all colors. But color happens in the middle, right? Where all the beauty lies. So I kind of take that philosophy and I put it to this question. And I'm now landing in the maybe column. For the record, I wasn't particularly impressed by how Judge Fleischer handled that emotional impact statement. Not that there was necessarily a problem with the impact statement itself, just he on a dime changed what he was going to do and was not allowing any kind of rebuttal argument. And it was because, in my opinion anyways, that situation got the best of him. You can't go over there, sweetheart. So I'm not of the opinion that emotion should completely turn the tide, but you can allow your emotion to inform your opinion on facts. We do that sort of thing all the time in real life, if you think about it. We can have a set of facts in front of us, but how we feel about them on an emotional or personal level will certainly affect how we react to it. So I bring this up, number one, because I've changed my mind as this poll's gone on and I've thought about it more. But one of the goals I have with this channel is for people to not just be black and white on things. I would love it as a community if we really think things through and take a look at both sides of an argument, because that's a skill that you need for everything in life. And you know, certainly when we look at courtroom stuff here too, it's often so many things are gray areas. But anyways, I just wanted to bring you my perspective on how this poll is going and how my views on it have evolved, and I encourage you to do the same thing. Let your views evolve. Let yourself be opened up to new ideas, new ways of thinking. You aren't... Whoa! Well, that was gymnastic of you. Anyways, let yourself expand your horizons, expand your thoughts. Live in the color. Don't just live in the black and the white. Go in the middle. That's where the beauty lies. That's where the real wisdom is. Anyways, let's go back to Judge West. She still has her parade of orange.
So you went to ISF because of parole last year in 2024. Is that before or after this allegation?
That was before. No, that was after. I caught my dirty way. That was March. I didn't get locked up to June. The crime was before.
The crime was in March.
Yes, ma'am.
And you went to ISF in June?
Yes, I'm supposed to get out in October.
Did you successfully complete that program?
Yes, ma'am. I had to come back for this detainer.
Right, okay. But they let you go even with this detainer to ISF?
Yes, ma'am. They didn't even know I had a detainer until I got there.
Okay. You still okay with it, Mr. Smith?
I believe so, Judge.
I'm wondering why there wasn't a felon in possession of a firearm case filed.
I checked it, I wasn't filed.
I mean, you can obviously tell, Mr. Mayfield, that I'm not loving all of this. Your criminal history, the fact that you were on parole, the fact that you had a gun while you were a felon, for some reason that didn't get filed. That's not my lane. I can't tell why that didn't happen. You're trying to kind of play around with your words on whether or not you did this or not. If I follow this agreement and place you on probation, I just want to make sure you understand it will be absolutely zero tolerance. There couldn't be a more zero tolerance than what you're going to be on. There will not be an I slipped up. There won't be I didn't have a ride. There won't be anything. Zero. Or you will be back in here and I will have up to 20 years in prison to send you. Do you understand? And there's no reason for me not to do that if you're back in here, if you get this opportunity. So they didn't find the firearm. That's probably why they didn't do it. Because you were smart enough to hide it. What is this? This is. Okay. No jail issues. All right, Mr. Mayfield, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement, defer all proceedings, place you on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. Again, you'll be on the high, medium risk caseload, and it will be absolutely zero tolerance. So you get out, you do everything you're supposed to, you understand what's happening today and how good of an opportunity this is. The other side of that, though, is if you violate a single condition of your probation. I want probation, it doesn't matter what it is, in my opinion, administrative or otherwise. I want it filed, and you will be right back in here, and you'll be looking to go to prison for anywhere between 2 years and up to 20 years in prison. Do you understand? All right. I'm handing you the trial court certification that shows this was an agreement that I filed, and so you've waived your right to appeal. Hope you take advantage of this opportunity, because if I take a look back at this and see that I did this today, I'm going to wonder why. Take advantage of this. All right. You go back with the bailiff.
Let's head back over to Judge Boyd's court for a minute.
All right, counsel, are you ready to proceed on the motion to revoke or no?
Yes, Your Honor, we're ready to proceed this morning.
All right, could I have a file stamp for a motion to revoke, please? Thank you. Did you do a trial court search?
In my haste, I may have forgotten that. Judge.
Okay, you may need to get it from the clerk.
I got it right here, Judge. I can sign right now, and I have my client sign as well. I already explained everything. Right there.
Did you understand it? Are you the same Victoria Castro Villarreal who was placed on deferred adjudication in 2020 CR 2212 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on July 2nd, 2020 for a term of 4 years? Is that you? All right, state.
In Bear and or DeWitt County, Texas, the defendant Victoria Castro Villarreal did then and there fail to report to the supervision officer as directed for the months of April, May, June, July, August, September, October, and November 2022 in violation of condition number 5.
How do you plead to that? True or not true? True.
State waives the remaining violation allegations, Judge.
No objection to the state waiving the remaining conditions.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5? All right, you're whispering.
Yes, ma'am.
Court is finding violation of condition number 5 true. Is there a proposed agreement?
I believe so, to adjudicate and sentence to 2 years TDC.
That is our understanding of the recommendation to the court, Your Honor.
What has she done on probation?
She has not reoffended, not picked up any new offenses, ever since this possession charge, Judge. In relation to her criminal history, this possession charge is the only thing she ever had. She may have bit off more than she can do in terms of the supervision. There was some issues with family that caused her to be somewhat homeless, mom losing the apartment that they were in, not affording her the opportunity to check in. And she was scared at that moment and just kind of just didn't check in because she thought she was going to get picked up at that point in time. Shortly after the issues with the family home. So she just didn't check in, Judge. But in reference to this charge and to the decision before the court, We asked the court to look at the charge which she's on probation for, she was on probation for, which is possession of controlled substance. It's a nonviolent offense. There are no victims other than the state of Texas and her doing this to herself in terms of the drug usage and the wear and tear on her body, Judge. She has 4 granddaughters. She wants to be there for them, to look over them. She has explained that she currently does not suffer from using substances in terms of addictions, but at the time of this offense, she was dealing with that. I went back to the original case and looked at the circumstances of that case, and it seems like the officer had seen a straw pop out of her pocket and there was some residue on it, which led them to uncovering some methamphetamine in her purse. Although it is classified as a second-degree offense, Judge, it was more or less around the 4-gram range. I think it was like 4.3 grams. So I know that's a large range, the 4 to 200, but we're in the bottom range of that, Judge. So I went over the options with my clients, notified her that staying on probation was going to be a stretch because of the amount of time that she had not checked in. But we're just asking for the honorable court to sentence her in reference to the offense, which is the possession charge. We know that she didn't do much of anything on probation, but she did stay out of trouble, did not pick up any new offenses ever since this 2020 offense, Judge. So this would be the first felony conviction for her and the first time for her going into prison. So being that that's the case and the circumstances, Your Honor, we're asking that the court honorably enter into the 2-year recommendation. I did notify my client that the recommendation is not binding on the court, but I told her I would offer this mitigation to the court so they can get a better look that she's not a career criminal or threat to the community or society.
All right, I have some questions for you. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record. All right, so did you complete intensive outpatient treatment with probation?
No, that's outpatient.
No,
Did you provide proof of employment?
no, I didn't do transport, I'm working.
I'm sorry?
We went, because my mom had to get out of her house, so we had to move to, Clark County.
All right, so how old are you?
It's 40.
All right, so you're 40. You're depending on your mom to support you and
That's when I
because,
first got out. I was trying to get back on my feet.
okay.
I did, they didn't get on, like the RV, the property and have like a little RV.
All right, so let me just tell you my issues with you. My issues are that we were here previously before for your not reporting. And you continue to not report. Reporting is the easiest thing to do on probation. All you have to do is report, and you didn't. That's a problem. And I don't know if you're clean or not clean.
I got two sons, I got my granddaughters, because my son, I lost my kid's GPS, but I got my children back, they aged out.
Mhm.
I'm not gonna leave my grandkids on something stupid like I did my
Well,
kids.
here's the thing. You're saying you're not going to lose your grandchildren. You are. You're about to go to prison.
Now I have no choice, but not, drugs.
I think the issue, Judge, if I may interject, and I apologize to the court for this, is that the time she was dealing with these issues of non-reporting, she was also seemingly dealing with her addiction issues. And I just feel that maybe after SATIF, which she did complete, Judge, that maybe some more intensive care would have been in line, but I feel like she was still struggling with those issues, which made reporting a little difficult for her, and she probably was fearful. But I've explained to her sometimes, a lot of the times we have to face our fears because if not, they're eventually going to catch up with us and it's going to be much more detrimental to our future than just facing up to the fear. And she's taken responsibility and accountability, Judge. She knows what she did was not correct. We're not asking that she be continued on probation. We understand the court wants to adjudicate her, but we're asking that the term of years is on the lower end as she's first time going to prison, first time being a convicted felon, and not reoffending, Judge.
Probation, has she done anything on probation?
Judge, she completed 119 days in SATIF.
All right.
She was working on it, Judge.
All right, this is what the court is going to do. The court is going to find you guilty. The court will revoke. The court will sentence you to 5 years in the prison, give you credit for any time served, request a therapeutic community. There's $1,000 fine. time and money to run concurrent. There's to be no unsupervised contact with minors. Credit for any time served in SATA. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Obviously, you have a drug problem. When you are released from prison, if you cannot find a place to go, if I'm still here, you come back here, I'll pick up the phone, call, so you can get in a place so you can maintain your sobriety. Because when you don't, one or two things gonna end up happening. Either you're gonna go down this line where you're gonna constantly be in and out of jail, in and out of prison, or either you're gonna get some bad drugs and somebody's gonna have to identify your body. And usually the person they have identify the body is a family member. So it's gonna, maybe your mom, maybe your children, maybe your grandchildren. You understand? All right, good luck to you.
May we go on the record briefly?
Yes.
So I can state the SATF dates upon a completion?
Yes.
As per the probation's court summary and also verification of my client, that she completed SATF for the dates of August 20th, 2021 through December 17th of 2021. And council just wanted to get that on the record.
All right, and if you'll just make sure that the clerks have that time.
Definitely will, Your Honor.
All right, thank you.
Well, that's a sad situation. Hopefully she gets it together. Stuff going on in Judge Fleischer's court. Let's see what's going on there.
Case,
Like 10 years.
it is not something I'm going to show.
Okay, so we'll set your bond at like I said, at 5,000. Don't pick up any new cases. Don't do anything to violate the conditions of this bond. Otherwise, it's not going to go well for you. Do you understand?
Yes, sir.
All I want is my community safe. I'm going to do everything in my power to protect it. So we'll have you now, since reset or no?
Are they posting their own bond?
Yeah,
Then we don't.
yeah, we're not going to do a reset at this time because what'll happen is he'll get a 7-day, we can't essentially. So once he goes posts bond, you will get a 7-day setting. Just reach out to Victoria, email, and then we can give you a further date. So you just don't have to come back in a week.
Thank you, Judge.
We'll have him sign all his conditions. Now, do not leave until you sign your conditions. And after that, we'll let you go. And then we'll let him go with the bonding company.
Thank you.
Yeah. Okay. Thanks, guys. All right. So do you mind filing the MOUP and the conditions, please?
Yes, Your Honor.
All right, Sean, you ready?
Yes, Your Honor.
Hey,
How are you?
what's the,
About to go pick a jury, so having some fun.
are you next door?
An 8.
Or an 8?
Yeah, there's one going on at 7 too, though. So I'm approaching on that, remember we had the Doug Evans plea and there was the superfine issue about whether it should be issued or not. And you had put it in place, but told me to just, bring something back to you. Wasn't sure the exact means about how to address it because I don't think it's on the judgment. So I don't know if it's something that we just tell probation or if it needs to be a pro tunc. But I found the code and how it speaks to the final conviction aspect of it. Because he just started getting text today about having to start paying it.
Okay.
And so I was like, well, let me get in here real quick. And,
Give me a
on
second.
it.
Let me, you know what? I'm gonna also reach out to my staff as well, my staff lawyer, to see
Okay.
essentially how we go around.
And can I give you a
Yes,
code section just to have on hand?
give it to me.
Okay, so it is 709001 subsection B. Yeah, and then that's where you'll see the final conviction language there about it. Okay, great. And if you need me to come back or file or anything like that, feel free to call or.
Let me, because I want to make sure I don't like to do things the wrong way. So let me send an email, give me a couple hours,
Sure.
and then I can get back to you. As soon
I'll
as
try and come back right maybe on a break or something like that.
Do you have the cost number handy?
Yes, I do. It is 251-8349. Thank you, Judge. I appreciate you.
Thanks. Guys, come on up. You ready?
Morning, Judge.
Hi.
I'm here on an off-docket matter. It's a request to amend bond conditions that is unopposed by the DA's office. My client, I guess we'll give the case number.
What's the cost number?
It's 2553235.
Is this on Miss Iwoma?
Yes, it is, Your Honor.
Okay.
Situation is that her husband has been given a promotion, and in late May, I think May the 27th, 26th, is being transferred to Blythewood, South Carolina, which is near Columbia, South Carolina.
Okay.
And she would request that she be allowed to go to South Carolina with her husband and appear either virtually at court appearances or be allowed to fly back to Houston for court appearances.
I don't think that there are any travel restrictions now, but it's a DWI second. So she must still comply with the conditions that she has as far as whether she has an interlock, whether she has a scram, whatever the conditions are. I'm okay with her going. I don't care where she goes, as long as she's in compliance with the bond conditions and she doesn't pick up any new cases. That's my only concern.
That's fine.
Did you get the cause number, Anthony?
Do we want to make adjustments to the random drug test?
No, I don't want to do anything special. I mean, she's got to remain in compliance. So the problem is that she may get called upon to do drug or alcohol or drug testing. If she does, she's going to have to go to a Quest diagnostic wherever she is. She could get that done there. I will not accept Punka City, a better drug test, because I want a reputable lab that's ASCLD certified, and I know that's not something where you can just buy a result. And I think that Quest is, pretty reputable. So if she gets called upon to do a drug test, she needs to go to a Quest, and it's on her to get it to you guys, to get it to us, so we know. She's still going to have to come down. Does she have an interlock or does she have a scram? Well, she's still going to have to come down to get it calibrated.
Okay.
So that's on her to come down to get it calibrated. And I don't know how often. She probably does that like once a month, I would imagine. So she's still going to have to get that done. That's not something that you can do remotely. So as long as she's in compliance, I'm okay where she goes there.
It's in the calibration period to make it every 2 months. Could you extend the calibration to every 60 days rather than every 30?
Because then I don't know if she's like out there and it'll take a while for me to, because I mean, theoretically, I'll extend it to 60 days. It's going to get her time to get over here. It takes me at least a couple of weeks to get it. So if she drinks on that day, I'll get the violation in 90 days. And then it just,
sure.
Yeah. So the thing is I can't show you guys favorable treatment that I wouldn't show to anybody else.
All right.
I want to be fair to every single person. Everybody gets treated the right way. So they're the same way. So I'm not saying no, but you just have to comply with the conditions.
Okay.
It may be more arduous because you're going there, but hey, that's the cost of doing business.
Can she, when her court's appearance is set, she needs to, I'm sorry?
Your appearance is waived.
Oh, okay, perfect.
We waive everybody's appearance. As long as you're in compliance, we may never even see you. Well, this is a second, so it's definitely, at some point we're going to see her.
Right, calculation done. All right, well, that's all we have, Judge. Thank you for your time.
Sure.
Thank you very much.
Yeah, let me do the bail order before I forget.
All right, well, he's between things. Let's go back to Judge West.
You are Melody, is it Meshy? Mesh. And Miss Mesh was previously here, entered a plea of guilty to the third-degree felony offense of forgery, as well as the third-degree felony offense of unlawful possession of a firearm by felon. I've received the pre-sentence report as well as a supplement that was provided with regard to some more specifics on those Louisiana cases. Did everyone receive that?
I have not received the supplement, Your Honor.
Y'all didn't? Well, they should have. Was it emailed to them? The supplemental thing would have been emailed to them or something, right? There's a supplemental report. No, it was sent after the PSI.
No, but usually they attach it to
Oh, okay, we need to just make sure they get those. It shows that it just kind of clears up some of those records unavailable, ones on the PSI from November 9th of 2011, which isn't really on there, so I'm not real sure where this came from. There was, well, maybe it's the, oh, that's when she pled no contest to the OWI, operating while intoxicated. 6 months in jail, mostly suspended, 24 months probation. Probation was revoked June 20th of 2013, ordered to serve a 6-month sentence. And then there was a OWI third offense that she pled to October 24th of 2012. Got probation, it was revoked, requiring her to serve the full 3-year term back in 2013. Couple other things that have to do with driving, but those are the main ones that are, looks like, weren't available on this. So, other than that, has everyone, any other additions or corrections to that report, Mr. Rojas?
Nothing.
Ms. Delfino?
Judge, I know Mr. Brown's PSIs as they always are very extensive and thorough. I have a little hesitation with the defendant's comments in her section about taking responsibility. I don't really believe she was just kind of innocent bystander as she claims to be. I think the nature of the offenses in my read of them, judge, do justify probation that the court agrees, but the reason for the straight offer was obviously criminal history and accident time alone. Or whatever the court thinks is appropriate.
And I have spoken with Ms. Mesh about those comments, Your Honor. She's, as far as the counterfeit goes, she's aware that the person she was with had that kind of history. She's aware that there were those documents inside the car. She should have known.
It wasn't just documents, the printer was in the car.
The equipment, yes, ma'am, the equipment that was in the car.
I mean, you can't act like you don't know that's going on if the printer and the counterfeit bills are in the car and you're passing them. Goodness gracious. Like I need to start today over. I mean, so Ms. Mesh, I don't know how long you've been sending it in here. Obviously, it's extremely disturbing to me. Number one, your criminal history. Number two, the fact that you're not taking responsibility for this at all. Even if it wasn't your idea, you're not taking any responsibility for it. And it makes no sense when you're in the car with the printer, with the bills, you go into stores, you're trying to pass the bills in the stores, and you're saying, well, I was just in the car and he put the gun in my purse and he did all that stuff and I didn't really know about it.
Yeah, that's not exactly right.
That's not right? So tell me what's right. Because you pled guilty under oath the other day.
I knew the gun was there, and I knew he did counterfeit. But I didn't think all the money he gave me was counterfeit. I really didn't.
Did you think some of it was counterfeit?
I'm sure, yes, ma'am.
Okay.
Yeah.
Well, just take the responsibility. You know what I mean?
Yes, ma'am.
It's not going to make it better for you to try to diminish it at this point. It's done. You pled guilty to it.
Yes.
It just makes it worse. If you stand in front of me and try to say, well, I didn't really, I mean, yes, you knew some of it, if not all of it, was counterfeit.
Yes, ma'am.
He's printing it in the car. Jeez. How long has she been in jail? Okay. Where will you live if I let you out on probation?
I live in Illinois.
I mean, And I'm guessing you must have lived in Louisiana most of your life, is that correct?
Yes, ma'am.
And then you moved over here?
Yes. I've been in other states, but, I stayed in Lubbock, Texas for about 3 years. And my grandson now is a heavy equipment operator and he's coming to work down here. My daughter does, cancer treatments in Houston.
I saw that. So you live with your niece and grandniece and now?
Yes, ma'am. Which she just had surgery too.
And all those things, I feel for everybody else in your family, but I mean, you're the one who got yourself here, you know? Okay. I'm going to find, Ms. Mesh, that you previously entered your plea of guilty freely and voluntarily. I'm going to find in cause number 24, DCCR 2378, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of forgery. I'm going to sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but probate that and place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Clause number 25, DCCR 0134, find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by felon. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do everything you're supposed to on these probations, then for all practical purposes, your case here in court is over. And you'll be able to serve your 10-year term while you're out on probation. The other side to that, though, is if you violate any condition of probation, and I want you to understand that means any condition. This is the second time I've said this today, and I feel like I might say it more. You will be on zero tolerance. Your criminal history doesn't really, on paper, you don't look like you should be given this opportunity. I trust Ms. Malfino, her look at the case. I'm going to go follow the agreement, but I want you to understand that if you don't take advantage of this opportunity and do everything you're supposed to, you're going to be right back in here and you're going to be facing those 2 10-year sentences that you've already agreed to. Do you understand? I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you already know this, but I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, ma'am.
Thank you.
You can go back with the bailiff. Okay, let me just go ahead and Curtis Larson, come back up.
Okay, first, Bodie, thank you. You know, I can't complain about where we're at. The channel's only 6 months old, and we're just a few subscribers shy of 16,000. We've had, 5 point some million views now, hundreds of thousands of watch hours, a devoted core audience here on the live show. But we've only been doing the live show a month now, really. Not that long. So it'll get there. The one thing that I won't do that a lot of channels choose to do is I won't go out there and try to buy subscribers. I want people to come across this naturally and embrace it and be a part of a thriving community. I also won't pander to what might be popular in the moment, because I want it to be real. I want it to be genuine. That's the biggest thing that's lacking in the world right now is things that are real and genuine. So that's kind of what we're going for here. The approach is a little bit different. I think it'll pay off in the long run. But I appreciate you saying that more people should find the channel. Honestly, the biggest thing you can all do, if you have social media, if you have a Facebook or a Instagram or a X account or whatever, is share. If everybody shares, it becomes kind of a snowball effect. So if you do like what we do here, share it. Put it out on your other social media and ask people to join us, whether it be for the live or for other videos or whatever. So anyways, I wanted to real quick, she put another person on a 10-year probation, and earlier there was somebody she put on a 10-year probation, and I'd put in the comments that 10 years is a long time for somebody to go, and I wondered how good their odds would be of successfully completing that. So while she was talking, I looked up some data. Currently, this is as of 2022, the data that I found, approximately 46% of people across the United States exit probation successfully. So just less than half exit successfully. In 2020, it was 66%. It fell after that. There's probably a COVID component there, I would imagine, as the court systems were all messed up and society was all messed up. I think it probably messed with that. Interestingly, if you are between the ages of 17 and 21, your odds of successfully completing fall all the way down to 18%. That's crazy low. Anyways, I just thought I'd share because I went on a hunt for data, because I was curious. Do people actually successfully complete this stuff? Let's go to Judge Boyd. Looks like she's got a new contestant lining up.
Correct, and we're waiting for the complainant to appear. And she is here. All right, I believe this is family violence.
I may have a manager. I'm trying to get Ms. Jones here. This is her case.
Okay.
Thank you.
Hello, just give us one moment. Are you the complainant, Samantha Hayes?
Samantha Rubio.
Samantha Rubio, okay.
Yes, ma'am.
We'll need that corrected. All right, the court is calling 2023 CR 3545 State versus John Thomas Hayes. Can I have parties announced for the record?
Ashley Jones for the state.
Alfredo T for the defendant, John Thomas Hayes, Your Honor.
And are you Mr. Hayes?
Yes.
All right, you entered a plea of true to violation of condition number 25, which is contacting the complainant, even though the court ordered no contact. And the court asked for this case to be recalled because the court was informed that the complainant was contacting the defendant. But then there were other issues where people were saying that she only started contacting him after he contacted her. So I want all of this cleared up so that I can make an informed decision on whether to continue him or not continue him. My understanding is that the complainant is here. She's present by Zoom. Can you raise your right hand for me, please?
Yes,
Do you
ma'am.
solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Samantha Rubio.
And were you previously Samantha Hayes?
Yes, ma'am.
All right, any objection to the witness appearing by Zoom, state or the defense?
Not from the state, Your Honor.
No objection for the defendant, Your Honor.
Any questions for the witness?
Not from the state unless you wanted the state to ask,
Yes, if y'all have, because I'm assuming you all are requesting revocation.
actually, Your Honor, I think we were requesting, the,
Continue.
yes, with the mental health, treatment that the probation was recommending. as
All
well.
right, then I have a question.
Okay.
All right, so, Ms. Rubio, you understand that I ordered that you're not, that the defendant, Mr. Hayes, is not to have any contact with you?
As of April 8th, yes.
No, I mean, this has been in effect since November 4th, 2024.
No, I was not aware. I was not at the hearing. I was only told on April 8th.
So you're telling me up until April 8th, you didn't know you were not supposed to have contact with him? Well,
I
I'm
knew there
sorry,
was-
I have no jurisdiction over you, but you're telling me that in April 8th, you just discovered that he's not supposed to have contact with you?
Yes, because I asked I think it was Marina when I spoke to her, what the conditions were. I was just aware that he was going to a health facility and he had 6 years probation because every time she contacted me, I was at work.
No, well, see, here's my thing. You're saying that you don't know that he's not supposed to have contact with you. And then I have a motion to revoke because he's constantly contacting you.
Again, on April 8th, when she told me there was a no contact because I asked what the conditions were, that's when I told her that he had contacted me.
All right, so here's the thing. You know you're not supposed to have contact with her. I don't know why you should remain on probation because my orders are very simple. My orders are no contact. Is there something somebody can explain to me then? Why doesn't he know that he's not supposed to have contact with her? Because it clearly states on his conditions, he's to have no contact with her. So whether she's contacting him or not, he knows he's not supposed to have contact with her.
There is a child involved, Your Honor. There's a 3-year-old child involved that they have a child together.
I understand that, but I told him no contact. And I always tell people when you have a child, guess what? You're going to have to go through a third party because we're here for a violation of bond protective order assault. So because you're here for a violation of bond or protective order, you know what that means? There have been previous orders that are in place that you have violated where a court has told you you're not to have contact with her. If there were not any previous violations, guess what? You wouldn't be in felony court for violation of bond or protective order. So I don't know if he's appropriate to be continued. I know the state is saying we want him continued. Probation may be saying you want him continued, but it appears that he doesn't understand what no contact means.
Your Honor, I want the court to consider the fact that Mr. Hayes has mental health issues. He has initially, I was not the attorney at the time, but initially apparently he was deemed incompetent, and so he had to regain competency. And in that time period, apparently he has been in custody 782 days, almost 2 years, more than 2 years. So if the court is going to revoke Mr. Hayes, I just want the court to consider that and consider the record that he shows that he has mental health issues.
Okay, because I just don't, nobody has given me any reason why he shouldn't be revoked because he's here for a violation of protective order, which means that a protective order has been placed and he's continued to violate it. That's why we're here. Otherwise, you wouldn't be in felony court. When a court orders no contact, that's what it means. This whole thing, the complainant is saying she didn't know she wasn't supposed to have contact. She did. And let me just tell you why I believe she did.
Can I say something?
No, you cannot. Let me tell you why I believe she knew she was not supposed to have contact. Because there's an order in place before they even got to this court that says he's not supposed to have any contact. So that means somebody had to go to court. And usually when they have on the civil side, these orders about no contact, the complainant is usually there and there's usually a representative for complainant. Normally, the person who has the protective order against them, usually they're not there, or either they waive or parties agree, you know what? We're just not going to have any contact with each other. So everybody knew there was supposed to be no contact. So when people come here saying they didn't know, they knew, because that's why we're here in the first place, because you previously violated a protective order. So there we are.
My understanding of
Why
protect.
should I revoke him?
And Your Honor, if the state could just speak in, speaking with the complainant, I'm happy to ask the complainant now since I have her. But in speaking with the complainant, we did discuss the options involving this motion to revoke probation. My understanding from our conversation was that she wanted him on supervision as long as possible and to get treatment rather than just go to prison with no treatment, him get out and then still.
Well, here's the thing. He can get treatment as prison. This is what I don't think people understand. What I've learned from these cases that involve violence, and I understand the circle of violence, I understand all of that. 9 times out of 10, from my experience as a prosecutor and a defense attorney, you know what people want? They want to remain in relationships with their partner who's abusive, right? Because they love them. but they want the court to make them behave. I can't make people be good boyfriends. I can't make people be good girlfriends. It just can't, I can't do that. And I cannot keep him on probation for the rest of his life so that he can be a decent father or a decent boyfriend. Can't do it. He has been violating my order. And when you look at the motion to revoke with him contacting her, it's March 20th, March 16th, February 14th, February 4th, February 2nd, January 25th, January 21st, January 19th, January 18th, January 12th, January 11th. Telephone, mail, or in person. I can't make people be good partners for people. I don't have that authority. Either people want to be a good partner or they don't. I know that's what people would love, a unit, for he to be in your life, for y'all to be a happy, loving family, and for him to be a good father. But I don't have any control over that. I don't think he's a good candidate. I don't know how many times I have to tell. That, I mean, that's the number one thing. Report, no contact. Whether she knew it or not, which I think she knew, he's not supposed to have contact. And if I were to continue him, you know what's going to end up happening? He's going to get released. They're going to have contact. She going to call him. Then he's going to come to me. And whoever's attorney is going to say, well, she's the one who contacted him. And this relationship is not going to work. So I don't think he should be continued. Is there a trial court certification?
Yes, we did, sign one.
All right, let me
First
see.
time.
Do you all want to agree on a time?
Your Honor, if we can have just a moment to confer.
Sure.
Thank you, Judge.
Okie dokie. Been at it 2 hours, 15 minutes now. So I think I actually need to bid you all a fond farewell for today. Again, this is a really, really busy week for me. But I'm going to do my best. We're going to do the lives. I'm not doing a live on Friday, by the way, not for Good Friday. A lot of people travel. A lot of people obviously have faith-based things going on. So not that day. But we will be back tomorrow. We will be back Thursday. I am going to post as I can with shorts and longer form videos. I've got notes of some things I want to do. But again, as I mentioned earlier in the show, I'm going to be upfront with you. This is a crazy busy week for things outside of this channel that I have to handle and accomplish. And on top of it, I've got a sick pet rabbit that we're dealing with now too, though I think she'll be fine. Just all of a sudden out of nowhere yesterday, we spotted a really nasty eye infection, but otherwise she's doing well. I just want to make sure that doesn't get out of control. So lots going on. Anyways, I hope you all enjoyed the show. I did. Some good back and forth in the comments. We learned a couple of things. It was good. Appreciate you all being here. Again, for channel members, I'll have more to say on it later, but we're definitely going to be working on massively increasing the amount of content available to you as a channel member. The one thing I will point out is if you like a certain judge, you'll like the content that's coming. We'll just leave it at that. If you're not a channel member, please consider becoming one. $2.99 a month really helps us out and really helps build that community of supporters, and I appreciate that. Anyways, enough of me rambling. Go on about your day. Have a happy Tuesday. We'll see you tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Take care. God bless.